A manslaughter conviction, multiple probation violations, a courtroom that already knows where this is headed before the defendant even says a word. But here's what makes this hearing so intense. It's not just about whether Brianna Renee Mitchell violated probation. She already admitted that. The real story is how someone who was given a second chance after a deadly case ended up back in front of the same justice system, facing the maximum sentence possible. And once the judge starts digging into the timeline, federal prison history, drug possession charges, evading arrest, and even a deadly weapon finding, this hearing turns from routine probation revocation into something much bigger. Now pay attention closely, because this case moves fast. Brianna Mitchell was originally placed on community supervision for manslaughter, meaning the court gave her the opportunity to stay out of prison under strict conditions. But prosecutors say she violated those conditions multiple times in a single incident: possession of a controlled substance, giving false identification, and evading arrest. And in Texas, when you're already on probation for a felony like manslaughter, those kinds of violations can completely destroy any remaining goodwill with the court. What's especially important here is the strategy. Notice how quickly the defense admits the violations are true. That usually means there's already a negotiated agreement happening behind the scenes. The defense isn't trying to prove innocence. They're trying to limit damage. But then another twist enters the courtroom: federal prison credit. The attorneys begin arguing over years of custody time that could drastically impact how long Brianna actually remains behind bars. And trust me, when judges start reviewing old federal custody records mid-hearing, you know every single day of sentencing matters. But then comes the moment that could change everything permanently: the discussion about the deadly weapon finding. That's not just paperwork. An affirmative deadly weapon finding can affect parole eligibility, prison classification, and future consequences long after sentencing is over. And the judge appears genuinely surprised it wasn't already formally addressed. So the big question is this: was this simply someone failing probation after being given a chance? Or was the outcome inevitable from the beginning because of the seriousness of the original manslaughter case? Watch carefully, because the judge's tone shifts dramatically by the end, especially when the conversation turns to parenting, accountability, and humility.
Are you the same Brianna Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter? All right. Did you understand by pleading true to violations 1, 1, and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
You're going to have to humble yourself. Right. Court is going to call 2020 CR 4098A, State of Texas versus Brianna Renee Mitchell. Can I have parties announced for the record for the state?
Brittany Sparks.
Defense?
The attorney of record, Monica Guerrero. I'm covering for Ms. Guerrero. Joseph Stateson. Ms. Mitchell, would you give this judge permission for me to do the plea in case of Monica Guerrero?
That's right.
All right. I'm going to need you to speak up, okay?
Yes.
All right. Are you Brianna Mitchell?
Yes, ma'am.
All right. I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Brianna Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter on December 10th, 2021 for a term of 10 years? Is that you?
Yes.
All right, state.
Yes, Judge. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of possession of controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of fail to ID fugitive intent to give false information in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True.
We'll waive the other violations.
Any objections to the state's waivers?
None.
All right. Did you understand by pleading true to violations 1, 1, and 1, The court could find it true, grant the motion, and sentence you up to 10 years in prison and up to a $1,500 fine. Did you understand?
Yes, ma'am.
This is one of the most critical moments in the entire hearing, and it happens in less than 10 seconds. When the judge asks Brianna Mitchell if she understands she could receive up to 10 years in prison and she still pleads true, that's essentially the legal equivalent of conceding the case. There's no trial here, no witnesses, no argument over facts. The violations are admitted directly into the record. And notice something else. The state immediately asks for the full 10 years in TDC, the Texas Department of Criminal Justice. That tells you prosecutors are not interested in extending probation, modifying conditions, or offering another chance at supervision. They're done negotiating. From the prosecution's perspective, once someone on probation for manslaughter picks up additional offenses involving drugs, false identification, and evading arrest, the court's trust has already been broken. What's fascinating is how calm and procedural the courtroom sounds while discussing something life-changing. That's how revocation hearings often work. There's no dramatic TV-style shouting match. Instead, everything becomes clinical: violation, admission, sentencing range, agreement. But beneath that calm tone is a devastating reality. A defendant who once avoided prison is now walking directly into a decade-long sentence. And here's a question for everyone watching. Should probation violations automatically trigger the maximum sentence when the original charge was this serious? Or should courts focus more on rehabilitation instead of punishment once someone slips up? Because depending on how you answer that question, this hearing probably looks very different to you.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
The court will find 1, 1, and 1 true. Is there an agreement?
Yes, Judge, we're asking that you grant the motion, revoke her probation, and sentence her to 10 years in TDC. In addition, Judge will be taking into consideration cause numbers 2022 CR 10345B, County Court cause number 692652, County Court cause number 692653.
Is that the agreement, defense?
It is, Your Honor, and I believe I may have made a clerical typo on the certificate of appeal. I may have put the case being TIC instead of the NPR. That's my mistake.
Yes. No, I'll correct that. Is there any objections to the court correcting that with the proper cause number?
None from the defense.
No.
And if I may put something else in the record, Your Honor.
Yes.
This offense was created during a time where Ms. Mitchell was on federal release, supervised release. She has federal back time, and post the offense, she did time in federal prison. I have some dates if I could put those on the record.
Yes.
She was in custody in federal prison or federal custody on April 18th, 2016, where she was sentenced November 17th, 2016. And she was not released until April 3rd, 2020. When she was released April 3rd, 2020, it was supervised release. And there was a revocation hearing. And she has federal custody time from February 18th, 2022 to April 13th, 2022. And we ask that she be given credit for federal time in addition to the Barrett County time.
So you're asking for credit from April 18, 2016 to April 13, 2020?
We are, and I did explain to my client that is prior to the offense date, but she was still in custody post that also, and that it's the court's discretion to award time.
So with regards to the dates from April 18, 2016 to April 13, 2020, was this case open on a motion to revoke or no?
I don't believe it was on a motion to revoke.
All right, was this case pending?
I have to,
Right.
I can
So-
check one moment, Your Honor.
Okay, so that's what I want to know about that. But with regards to the February 18th to 2020, February 18th, 2022 to April 13th, 2022, this was pending, correct?
Now, this section right here is incredibly important because it shows how sentencing is often about math, timelines, and technical custody records, not just guilt or innocence. The defense is aggressively pushing for federal time credit, and they're trying to make sure every possible day Brianna Mitchell spent in custody gets counted toward this 10-year sentence. Why? Because credit for time served can shave years off actual prison time. Listen carefully to the judge's questions. She's not simply accepting the request automatically. She wants to know whether the case was active during those federal custody periods. That distinction matters legally. Courts usually don't just hand out custody credit unless there's a direct connection to the pending case or revocation status. So when the clerk confirms the case was already on the system back in 2016, you can almost feel the courtroom recalculating the consequences in real time. And honestly, this is one of those moments many viewers overlook in courtroom hearings. Everyone focuses on the sentence itself, but experienced attorneys know the real battle can become parole eligibility, custody calculations, and sentence credits. Two defendants can both receive 10 years and end up serving drastically different amounts of actual time depending on these technical details. Also notice how professional and careful the defense attorney becomes here. There's no emotional argument, no dramatic speech, just precise dates, federal custody records, and legal positioning. That's strategy. Because once the plea agreement is accepted, this is one of the few remaining areas where the defense can still meaningfully help the client.
Yes.
All right, so she will definitely receive credit for those dates. I just need to check on the April 18th date. Can you look for that too?
So that was the next one. Fairly,
So when this case was on the system, what date was that again?
February 22nd. And then she was running patient 12-10.
All right. Well, it appears, Ms. Sparks,
Yes, Judge.
on this case, I'm being informed by the clerk that this case was actually on the system January 2nd, 2016.
Yes, Judge, that's what our computer shows.
Okay, so we can go back on the record printer. So are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court is finding 1 and 1 true. The court will follow your agreement, revoke, sentence you to 10 years in the prison, take in consideration 2022 CR 10345B, County Court Cause number 692652, 692653, give you credit for any time served, and the court will give you the credit served in federal custody from April 18, 2016 to April 3rd, 2020, and February 18th, 2022 to April 13th, 2022. Is there anything else from either side with regards to sentencing?
No, Judge.
Nothing from defense.
All right. For some reason, there's no affirmative finding on this of a
On the
deadly weapon.
original?
Yes. Let me see something, just one moment. I don't know what the underlying facts of this case were. Just give me 1 second. I'm assuming a weapon was involved, be it a vehicle or something else. All right, yeah, it's involved a gun.
It appears that my client appears that it was with the co-defendant who had a gun. Her client didn't have a gun, but that was not negotiated with the district attorney's office with Marcus prior to this.
All right, because I mean, according to the, and I know this is before your time, Mr. Statesman, but according to the indictment, it says that Brianna Mitchell did recklessly cause the death of an individual, namely, the complainant by discharging a deadly weapon. So this is pre this attorney, Ms. Mitchell, but that's what's in the paperwork. So there's going to be an affirmative finding.
And there it is, the moment the hearing takes an even more serious turn. The judge officially enters an affirmative deadly weapon finding into the record. That might sound like legal jargon, but make no mistake, this has major consequences. In many cases, a deadly weapon finding can impact parole opportunities, prison classification, and how the justice system treats the defendant long-term. What makes this moment especially striking is that the judge appears to discover the issue while reviewing the case paperwork in real time. Once she reads the indictment language describing the complainant's death involving the discharge of a deadly weapon, she decides the finding needs to be formally recognized. Even though the defense notes the co-defendant allegedly possessed the gun, the indictment still ties Brianna Mitchell to the deadly weapon allegation under Texas law. This is also a reminder that plea agreements don't erase the underlying facts of a case. Even years later, during a probation revocation hearing, those original allegations still carry enormous weight. And from the judge's perspective, that original manslaughter conviction likely shaped every decision made in this courtroom today. Then comes another harsh reality check. By waiving her right to appeal as part of the plea bargain, Brianna loses one of the few remaining avenues to challenge the outcome. Once that agreement is locked in and accepted by the court, the legal road forward becomes extremely limited. So let me ask you this. Do you think the deadly weapon finding was legally necessary based on the indictment, or should the court have considered the defense argument that she personally didn't possess the gun? This is exactly the kind of detail legal analysts debate for years after cases like this.
So there's an affirmative finding of a deadly weapon. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck. We can go off the record. I saw in this case where parenting classes were ordered for you. So here's the thing. Someone else is taking care of your children or your child. When you are released from prison, and at some point you will be, do not go up to the house acting as though, here I am, let me put my rules in place and disregard whatever rules have been set for your children. You understand? You're going to have to humble yourself. All right, good luck to you.
By the end of this hearing, the outcome is clear. Brianna Renee Mitchell's probation is officially revoked, and the court sentences her to 10 years in prison after she admitted to multiple violations tied to new criminal conduct. But what makes this case stand out isn't just the sentence, it's the layered legal consequences surrounding it. The court addressed federal custody credits dating back years, confirmed additional county-related cases tied into the agreement, added an affirmative deadly weapon finding, and finalized a plea bargain that eliminated her right to appeal. And then came the judge's final comments, arguably the most personal moment of the entire proceeding. Instead of ending strictly on legal procedure, the judge shifts toward accountability and parenting, warning Brianna not to return from prison, expecting to immediately take control over her children's lives without respecting the stability others may have provided during her absence. That wasn't just courtroom advice. It was a blunt reality check about consequences extending far beyond prison walls. Cases like this show how probation can truly become a crossroads in the justice system. Some view probation as an opportunity for rehabilitation and second chances. Others see repeated violations, especially after a manslaughter conviction, as proof that incarceration becomes unavoidable. And depending on where you stand, this hearing may feel either completely justified or deeply tragic. One thing is certain. Every decision in this courtroom carried lasting consequences, from the initial plea to the final deadly weapon finding. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you, Judge.
Thank you.
Checking in on